Good morning and welcome. This hearing of the Capital Markets Committee and GSEs entitled Oversight of the SEC's Division of Corporate Finance is hereby called to order. Welcome, Mr. Higgins. We will begin by opening statements up here and then look to you for your testimony and go from there. So, I'll give myself about 7 minutes. 7 minutes, I think. Thanks. So today's hearing will focus on oversight of the SEC's Division of Corporate Finance, CorpFin. Director Higgins, thank you for agreeing, as I said, to join us today and for all your hard work that you're doing over at the SEC. I want to start off today's hearings by commending Chair White, the other SEC commissioners, and Director Higgins for your recent decision to remove a potential corporate political disclosure rulemaking from the SEC's Reg Flex agenda. Far too often during the span of this administration, it appears that supposedly independent regulators use their position to carry out heavy-handed partisan political attacks, whether it is the targeting of specific political groups by the IRS, the armed raiding of the Gibson guitar by the Justice Department, the abusing of the law by the National Mediation Board, the bullying of fellow commissioners by the former head of the Nuclear Regulatory Agency, the obstructing of an investigation by the Chemical Safety Board, the lying of the delays by the VA Department, or the illegal implementation of Obamacare by Health and Human Services, and the list goes on. The Obama administration officials and their appointed regulatory cheerleaders need to stop putting political politics above the rule of law. It is not appropriate to abuse government-granted power to threaten, cajole, intimidate, or pressure any opposition into submission. So I want to thank Chair White for not letting the SEC fall victim to this and for standing up for the SEC's political independence from the White House. I'm pleased that the SEC is not joining in this conga line of partisan regulatory abuses and is not turning the disclosure process into a political piñata. After all, the SEC is a disclosure-based agency, and ensuring the appropriate disclosures of material information to investors is at the heart of the SEC does. And the staff of the Division of Corporate Finance is at the forefront of this important work. I also want to thank Chair White and Director Higgins and the staff of CorpFin for their ongoing work to refocus the SEC's disclosure regime on its original purpose. Specifically, I commend them on attempting to address the problems of disclosure overload and for looking at ways to streamline and modernize the antiquated SEC disclosure regulatory regime. If the disclosure process is to be useful to investors, the information required to be contained in the disclosures must be material to the investors and formatted in a way that can be easily utilized by the reader. Over time, more and more requirements have been added to the disclosure, rendering them now almost useless to the average retail investor. So we must prioritize reforming this regime to ensure that investors have the appropriate information to make informed investment decisions. By getting what I would say back to basics of disclosure, I believe we will unlock additional investment capital in our public markets. Another area where I would like to commend Chair White and the Director Higgins again is your recent work on proxy advisors. The guidance the Commission put out several weeks ago is very good first step in addressing the growing and outside influence being wielded by the proxy advisory industry. So by clarifying the investment advisors are not required to vote every share of stock they hold for their clients and not every recommendation of the proxy advisors must be followed, the SEC reduced the importance of the proxy advisors in the proxy process. While these steps taken are very positive, there is still more that should be done. Similar to the worries regarding the extraneous corporate disclosure requirements, there is also concern about the irrelevant and unnecessary shareholder proxy proposals being brought by activist corporate gadflies. You know, in a recent speech, Commissioner Dan Gallagher stated, quote, "Taking money out of the pocket of someone investing for retirement or their child's education and using it instead to subsidize activist agendas is simply inexcusable. It is incumbent upon the Commission to create a regulatory environment that promotes shareholder value over special interest agenda." Unquote. I could not agree more with Commissioner Gallagher. The SEC must take action to limit the abuses being committed by superfluous activist proposals that run counter to and promoting actual shareholder value for the actual investor, the average investor. Specifically, the SEC should amend a number of the rules that govern which investors can offer what shareholder proposals, including four things: increasing the current percentage ownership threshold, lengthening the holding requirement time, providing more specifics around what constitutes ordinary business operations and significant policy issues, and fourthly, strengthening the resubmission thresholds. Like the disclosure process, we must also refocus the shareholder proposals so that proposals to address and promote shareholder value receive the attention and consideration they're due. I have highlighted a number of initiatives of the Commission that I'm pleased with. Let me turn to several that I have a number of concerns with. The first is the implementation of the Jobs Act. It is unfortunate indeed that the SEC still does not embrace its mission to promote capital formation with as much zeal and enthusiasm as it does with Dodd-Frank. Our markets and economy are worse for it. This committee recently passed legislation that I sponsored entitled the Private Placement Improvement Act. So the purpose of this legislation is to ensure that issuers and investors in certain private offerings under Regulation D, Reg D, do not face overly complex and burdensome regulatory obstacles. So last year, the SEC adopted a rule lifting the ban on general solicitation and advertising in private offering under Rule 506 of Reg D, as mandated by Title II of Jobs Act. Unfortunately, the SEC did not stop there. Instead of simply removing the ban as intended and opening up this market to new potential investors, the SEC decided for some reason to issue a separate rule proposal, not called for at all by Congress, and that would impose a number of new burdensome regulatory requirements on issuers seeking to use Rule 506. As one commenter put it, the Jobs Act on its face does not authorize the Commission to attach new and additional conditions to the use of the exemption. It is not for the Commission to rely on its general rulemaking authority to bring Congress and the President back to line by adding conditions that it believes may enhance investor protection. However, that is exactly what the Commission did in that case. I believe that many of the additional requirements of the SEC's Reg D proposal will, if ultimately adopted, make Rule 506 a less attractive avenue for small business capital formation. This, then, is clearly at odds with the goals, let alone the text, of the Jobs Act. And finally, I would like to raise the ongoing review by the SEC of the accredited investor definition. And let me be clear on this point. At a time when small businesses continue to struggle to raise capital, investors are having difficulty earning a return on their investment, the SEC should not harm small business job creators or the investing public by reducing the amount of participants in this field eligible for private placement. While I know there is a long-held understanding that not all investments are appropriate for all investors, I find it difficult to believe that the SEC will know where to draw the line better than each individual investor. If the SEC decides to act on this, I do encourage it to err more on the side of allowing for investor choice and additional investment options rather than telling more investors whether they can and they can't invest their own money. So with that, I want to thank you again, Mr. Higgins, and I now recognize Mr. Scott for...
Thank you very much, Chairman Garrett. And I want to thank Mr. Keith Higgins, who is the Director of the Securities Exchange Division of Corporate Finance, for testifying before our committee today. The Securities and Exchange Commission has a good and necessary mission, and that mission is to protect investors, to maintain fair and orderly and efficient markets, and to facilitate capital formation. And any reorganization of the SEC should be made in mind to increase its effectiveness in achieving its mission and in streamlining the cooperation with other permanent federal agencies. In support of the Commission's mission to protect investors, maintain fair and orderly and efficient markets, and facilitate capital formation, the Division of Corporate Finance seeks to ensure that investors are provided with material information in order to make informed investment decisions, both when a company initially offers its securities to the public and on an ongoing basis as it continues to give information to the marketplace. The division also provides interpretive assistance to companies with respect to the SEC rules and forms and makes recommendations to the Commission regarding new rules and revisions to existing rules. I'm interested in finding out what changes have been made since the implementation of Dodd-Frank, whose fourth anniversary we celebrate today. And if the SEC is able to conduct any additional reforms in order to improve the Commission's effectiveness, well, I would certainly welcome such reforms. Furthermore, I anticipate the opportunity to discuss rulemaking and implementation emanating from both Dodd-Frank as well as the Jumpstart Our Business Startups, or the JOBS Act. We need to make sure that in this legislation and subsequent rulemaking that we still allow the Securities and Exchange Commission to evolve with market changes, and that we are not preventing the Securities and Exchange Commission from conducting its intended purpose. Also, I'm very much interested in working and getting an update on how the SEC is progressing with the CFTC in their joint rulemaking for cross-border harmonization and derivatives and swaps dealing. As you know, this comes under Section 7 of the Dodd-Frank law. It is imperative that the Securities and Exchange Commission get together and do this joint rulemaking. The delay causes confusion in our international markets, and failure to come up with harmonization for our cross-border in dealing with our swaps activity puts our business community working on the international stage at a very serious competitive disadvantage, and could very well allow for a possible reimportation of risk. It is very important, and may I conclude, Mr. Chairman, with this. Key to this cross-border is to make sure that the top 8 foreign jurisdictions who engage in swaps activity have equal, robust regimes to ours. And in order for us to facilitate that, it is you and the CFTC that will determine that, to report back to Congress within 30 days if one of these jurisdictions does not meet our robust regimes. So there's a lot to do there. I'd be very interested to know how quickly CFTC and the SEC will come together in harmony on rulemaking for cross-border swaps and derivatives activities. With that, Mr. Chairman, I yield back about some time.
Thank you. And the gentleman yields back to the Vice Chairman of the committee, Mr. Hurt, for 2 minutes. Recognized.
Thank you, Mr. Chairman. Mr. Chairman, thank you for holding today's subcommittee hearing to conduct oversight over the SEC's Division of Corporation Finance. The division has a number of consequential initiatives on its agenda, including the review of our corporate disclosure system and finalizing key pieces of the JOBS Act, and I'm looking forward to hearing your testimony today. I'm encouraged by Chair White's comments on the need for the Commission to conduct a review of its corporate disclosure system. As she and other commissioners have noted, disclosure overload is having negative impacts on investors, public companies, and the SEC itself. Fostering capital formation in our capital markets requires consistently reliable information on public companies. However, too much information, for the sake of information, can create inefficiencies and confusion. Streamlining our disclosure regime to better reflect the SEC's mission of protecting investors, maintaining fair, orderly, and efficient markets, and facilitating capital formation will lead to benefits for both business and investors. I also want to emphasize that it is imperative that the SEC not lose sight of its third important and sometimes neglected mission, again, facilitating capital formation. Congress has provided the SEC with broad discretion to amend securities laws and regulations without sacrificing key investor protections. However, the JOBS Act and numerous bipartisan bills that have passed out of this committee highlight the fact that the SEC needs to do more to promote capital formation through common sense updates to its regulations. One such bill that Representative Sewell and I have introduced passed this committee with strong bipartisan support to provide relief to small issuers from the disproportionate cost of XBRL compliance. The SEC should recommit itself to promoting capital formation that will spur growth and opportunity, beginning with a full implementation of the Jobs Act, as well as other recommendations from the SEC's Forum on Small Business Capital Formation. I'd like to thank Mr. Higgins for appearing before our subcommittee today. I look forward to your testimony. Thank you, Mr. Chairman. I yield back the balance of my time.
And I do thank the gentleman, and the gentleman yields back. The gentleman from California is recognized for 4 minutes.
4 minutes, thank you. Number of issues I'd like to get into. One of those is the FASB lease accounting project that I realize comes not directly under your purview, but you are to some extent responsible for the need for total disclosure, for full disclosure, and leases are being properly disclosed now. Since it's not broke, the folks in Norwalk, Connecticut feel they need to fix it. The effect will be to add $2 trillion to the to the liabilities on the balance sheet of American business, cause many tens of thousands, I'd say many hundreds of thousands, to be in violation of their loan covenants, and perhaps cut our GDP by about half a point. Others on this committee have heard me talk about this, and I hope that you would realize, as your chairman has stated here, that while you can say you've delegated everything to the Financial Accounting Standards Board, that this is an SEC responsibility. Second, you're about 2 years behind on issuing regulations under the Franken-Sherman amendment to deal with credit rating agencies. They gave AAA to Alt-A, and the economy tanked. All of the same pressures are there now. That is to say, the issuer of the bond selects the credit rating agency. If I had been able to select the people who graded my tests in college and been able to pay them an average $1 million per test they graded, I would have done better in college. Day trading and now minute trading, second trading, millisecond trading is an issue that comes up. It makes people think that they can't invest in a fair market if they don't have a computer that is specially wired to the market to beat somebody else's computer, let alone any human making the decision. It used to be that if there was a tiny spread, sometimes that went to the buyer, sometimes that went to the seller. Now all of it is scooped up by those engaged in this computerized trading. And it's also very hard to see what benefit is provided by having some of our smartest young people sit at home all day, avoid shaving, and spend the whole day buying and selling stocks and being out of the market at the end of the day. I think there's a role for people to make money in our capitalist system, but it usually should be tied to something socially productive. And finally, Mr. Higgins, I hope you'll discuss either in your opening statement or in questions the fact that the British and others have transactions taxes. How can we establish a per transactions tax that is low enough that it doesn't push business offshore? I think London's doing pretty well, and it would have the effect of raising some revenue, because I'm here. You're here to tell us that the SEC doesn't have sufficient revenue to do its job, such as writing the regulations under the Franken-Sherman amendment that you're 2 years late on, just in case I didn't mention that. And it would also have the effect of discouraging meaningless trades where people are in and out of a stock in a minute or a second. So I hope you'll address those issues in your opening statement. I yield back.
Gentleman yields. Mr. Rice is recognized for 2 minutes.
Thank you very much, Mr. Chairman. First, let me welcome Mr. Higgins and say thank you. To date, your office has been very professional and forthright in their interactions with me and with my staff. And I would also praise the Commission because over the last 5 years, it's been very active in the pursuit of insider trading. I think you've charged now over 570 defendants in civil insider trading cases over that period of time. So it is easy for our constituents to understand insider trading when it involves a group of friends sharing information, maybe over the golf course or through an email exchange between them. It becomes a little murkier for investors, and I assume for the SEC, when the exchange of information is shrouded in contracts and it doesn't look like something that you have seen before. I am very interested in the Commission's process for looking at novel and creative deals to ensure that they are robustly reviewed to ensure strong investor protection and market transparency in places where people would try to use insider trading as part of a scheme. And I look forward to your answers to some questions on these issues this morning. And again, I thank the Chairman for holding this hearing, and I yield back.
Gentleman yields back. Okay. The gentlelady from New York is recognized for 3 minutes, or how much time is she going to consume?
Well, first of all, I want to thank you, Mr. Chairman, for holding this important hearing, and a welcome to Mr. Higgins. There's been a great deal of discussion lately of maintaining confidence in our markets, and I've always said markets run more on confidence than on capital, and it's important that we maintain it. But one of the most important and most underappreciated sources of confidence is the accuracy and transparency of the financial statements that public companies are required to file. And this is where the SEC's Division of Corporate Finance plays such an important role. As an investor, if you're going to commit your capital to a company, you need to know at a minimum how much money the company already has, how much it's expected to make every quarter, what its normal day-to-day operating costs are, and how much it already owes to other creditors. This is the information that public companies are required to disclose every quarter in their financial statements. If an investor cannot have a basic level of confidence in these financial statements, that the numbers are accurate and any major caveats are disclosed, then the investor won't commit his capital to this company, period. The fact that investors around the world are so willing to invest in our companies and our markets is a testimony to the professionalism and dedication of the SEC staff who review those financial statements. And it is difficult work, sometimes tedious, often frustrating, and always complex. The confidence that investors place in these financial statements has been hard-won over several decades, but it's truly the grease that keeps the wheels of commerce spinning. So I look forward to hearing from our witnesses today, and I yield back the balance of my time.
So the gentlelady also yields back, and at this point, we turn to our panel for our witness. Mr. Higgins, you were recognized for 5 minutes. Obviously, your written statement has made a complete part of the record, and as with everyone, we're reminding you to pull the microphone as close as you can. That's not inconvenient to you. And again, welcome to be here, and you were recognized for 5 minutes. Mr. Higgins.
Thank you, Chairman Garrett, Ranking Member Maloney, members of the subcommittee. My name is Keith Higgins, and I'm the Director of the Division of Corporation Finance at the Securities and Exchange Commission. I appreciate the opportunity to testify today on behalf of the Commission about the Division's activities and responsibilities. As has been said already, the mission of the Commission is to protect investors, maintain fair, orderly, and efficient markets, and facilitate capital formation. The Division promotes this mission by overseeing the agency's review of corporate disclosures, disclosing to the investing public, seeking to ensure that investors have access to materially complete and accurate information upon which to make voting and investment decisions. The Division generally carries out its mission by selectively reviewing company filings, by providing interpretive guidance about the securities laws, and by making rulemaking recommendations to the Commission in the areas of company disclosure and securities filings. Through our filing review program, the Division reviews the disclosures and financial statements of reporting companies to monitor and enhance compliance with our disclosure and accounting requirements. The Sarbanes-Oxley Act of 2002 requires the Commission to review a company's disclosures at least once every 3 years, and more frequently where circumstances warrant. In addition to these mandated reviews, the Division selectively reviews registration statements and other filings relating to public offerings, business combination transactions, and proxy solicitations. During fiscal 2013, the Division reviewed the filings of more than 4,500 reporting companies, and I expect our reporting company review statistics will be similar for fiscal 2014. Division also provides guidance to market participants and the public through, among other things, no action and staff interpretive letters and staff and legal and accounting bulletins. Most recently, as the Chairman mentioned, the Division, together with the Commission's Division of Investment Management, issued a staff legal bulletin on proxy advisory firms that provided guidance on the availability of exemptions under our federal proxy rules, upon which these firms typically rely. It also provided guidance to the investment advisors about their responsibilities in voting client proxies and in retaining and overseeing proxy advisory firms. As to our rulemaking efforts, the Division has been focused on implementing the mandatory rulemaking provisions of the Dodd-Frank and Jobs Acts. Under Dodd-Frank, the Division has been involved in numerous completed rulemakings, including say on pay, say on frequency, and executive compensation, disclosures about representations and warranties and asset-level review of asset-backed securities offering, compensation committee listing standards and disclosure, disqualification of bad actors under Rule 506, specialized disclosures relating to mine safety and conflict minerals, as well as removing the person's primary residence from the net worth calculation in the accredited investor definition. Division is currently developing recommendations on the following for final rules on the following: on disclosure of asset-level data in offering of asset-backed securities, risk retention for securitizers of asset-backed securities, and on the CEO pay ratio. We're also working to implement the remaining Dodd-Frank executive compensation rules and payments by resource extraction issuers, as well as working on the mandated review of the accredited investor definition. Division's also been leading a number of the rulemakings under the Jobs Act. As the Chairman mentioned, last year we adopted final rules on general solicitation in Rule 506 offerings, and at the same time issued a rule proposal to amend Regulation D to enhance the Commission's ability to assess the development of the private offering market. In October of 2013, the Commission published a proposal to implement the crowdfunding rules under the Jobs Act. And in December of 2013, the Commission proposed rules to enable companies to offer up to $50 million in any 12-month period under a new and expanded Regulation A. Division's preparing recommendations for final rules on the Regulation D, crowdfunding, and Regulation A proposals. And we're also working on proposals to implement the Title 5 and 6 changes to the 12G standards under the Exchange Act. Finally, the Division, as the Chairman has mentioned, is leading the Commission staff's effort to comprehensively review our disclosure system, to review the rules that specify what companies must disclose in their filings, and to make recommendations on how to update them to facilitate timely, material, and more effective disclosure. Initially, the Division is focusing its efforts on the business and financial disclosures that are included in periodic and current reports, after which we'll focus on the governance and compensation information that's provided in proxy statements. The staff seeks input from a broad range of companies, investors, and other market participants on how to modernize and update the disclosure so we can make it more meaningful, both for investors and less burdensome for companies. Thank you again for inviting me to testify today, and I'm happy to answer any questions you might have.
Thank you again for your testimony. So at this point, I recognize myself for 5 minutes and just have a few matters to go over. You went through a whole series of things as far as what has been done and the listing of things that are on the plate still, I guess. One of which was one that I touched upon in my opening statement, and that was with regard to proxy advisory firms. And as you indicated, you recently issued guidance, and as I said in my opening statements, that they seem to address the concerns raised by me and also raised by investors and businesses also at the past SEC roundtables and also at the hearings that we held here in this committee last year. From our reading of it, the guidance appears to require the advisory firms to disclose, for one thing, conflict of interest. Also, it requires they put in a system in place to address those conflict of interest, and also to try to ensure accuracy, to correlate advice to the goals of the client fund, and clarifies when institutional investors must vote shares and how they must engage in advisory firms. I think I touched upon that in my opening statement as well. So all those things are important steps, I think, forward in creating oversight over these firms and ensuring a fair and what we would call an even-handed shareholding voting process. But just a couple points to dig into a little bit. How is the SEC going to, now that you've done this, how is the SEC going to try to oversee the implementation of all this with regard to the advisory firms?
Well, Mr. Chairman, we keep our eye on, we monitor the market. The guidance is out. It's the proxy season really is typically the first 4 months of the year, so we're sort of in a lull in proxy season. But we'd expect to watch to see what happens. We get feedback from market participants as to how it's working, but we don't yet have a work plan on how we're going to test how well the guidance did. We expect, because market participants haven't been bashful in letting us know where the problems are, so we're hoping that we continue to get feedback from all sides of the question.
Okay, so just to go down on one point, as far as the conflict, there's not like there's not going to be a reporting requirement on the conflict for each particular one that they identify then, for example?
What the guidance said is that the obligation, if there is a significant relationship that has to be addressed, the guidance said that the proxy advisory firm must provide that to the client on or about the time that it delivers the report. And we're confident that the proxy advisory firms can implement that. There's no one-size-fits-all.
Right. So, okay, so we're in the lull because we just passed this now. So when we get through the next period, the next season of proxy advisors, will you be reporting back to us? Will you be issuing a report? How do we know as far as the success of or not in this area?
Right. We don't have any current plans to issue a report, but it's something we'll give some thought to. As far as how you measure success, it'll be hard. There'll be some things that won't be particularly transparent to us. You mentioned the guidance provides some guidance on how clients can agree with their investment advisors when and how to vote shares. Those would be agreements that we might not be privy to. If they're registered investment advisors, our Office of Compliance and Inspection and Examination could take a look at that, could add that to the list of things that they look at when they come in to do their exams.
All right, my time is going by. Moving on to shareholder and proposals and what have you, do you agree with me that the SEC should amend a number of the rules that govern which investors can offer what and what shareholder proposals? I won't go down it, but just in general in that area?
Well, there's certainly been a lot of angst on the shareholder proposal process. The one thing about it is that nobody is completely happy with the process. We understand that. I think that we have a shareholder rulemaking petition in on resubmission thresholds. Commissioner Gallagher's given speeches on the initial submission thresholds. All of those are issues on which there's widespread debate. I don't think the staff doesn't have a view on what should be done. I think the only observation I would make is that any proposal will need to accommodate and try to find a consensus.
So let me just, my time's almost out here. So will you commit to proactively monitor the proxy voting process to ensure that it's not abused? Because there's allegations, I'm sure you hold from stakeholders, that certain activist shareholders are trying to do things through these methods that they maybe cannot accomplish in another means. So will be your goal to try to proactively monitor what they're doing, the proxy voting process, ensure that it's not abused by just this small class of what we'll call activist shareholders and special interest groups who are looking to advance their own particular goals that may not be to the detriment overall of the other investors and other shareholders?
Well, if this is on the 14A shareholder proposal process, we devote a substantial amount of staff resources every year during the 3 months of the proxy season on reviewing shareholder proposals, on calling balls and strikes, if you will, on what proposals can be included and excluded. So
Okay.
we're actively involved in watching that process.
All right, appreciate it. Gentlelady from New York is now recognized for.
Thank you. Mr. Higgins, earlier this year, the New York State Common Retirement Fund, which is overseen by our State Controller, Tom DiNapoli, tried to get a shareholder vote at the annual meeting of two large financial institutions on a resolution concerning the disclosure of incentive-based compensation for employees that take high risks for these institutions. Unfortunately, both of the financial institutions decided to exclude the controller's resolution from their proxy materials, and the staff in the Division of Corporation Finance sided with these institutions in this dispute, saying that the financial institutions could exclude the resolution because it dealt with so-called, and I quote, ordinary business operations, end quote. This seems to be contrary to the SEC's previous statement that incentive-based compensation for bank employees who take material risks is in fact a significant policy issue and does not merely concern so-called ordinary business operations. Because the staff's decision appeared to be based on a simple misreading of the resolution, the controller tried to appeal the decision to the full commission, but the staff refused to even present the appeal to the commissioners. And this was very troubling to me. I know that throughout the hearings on Dodd-Frank, the incentives were talked about, that incentives were there to increase risk as opposed to sound financial practices. This was troubling to me, and can you please explain to me how this happened?
Right. Well, the proposal of which you speak, the reason that the staff concluded that it could be excluded was that it's a very technical area, but that the proposal was drafted to focus on employees who could expose the institution to material risk. That was the first cut that needed to be made. The second was then to look at any incentive compensation those persons might be paid. The significant policy issue, and again, this is technical issues that maybe only a lawyer can love, but the significant policy issue had to do with incentive compensation paid to individuals who expose an institution to material risk. The proposal was, as drafted, talked about employees who could expose the institution to risk, whether or not they received any incentive compensation. On that basis, and again, a very technical, but that's what on that basis, the staff did not believe it met the significant policy initiative or issue test, and as a result, agreed with the company that it could be excluded.
Okay, well, you could commit to working with the New York State Common Retirement Fund next year ahead of time so that we can avoid this situation from happening again.
The one thing about the shareholder proposal process is we stand in the middle. We provide informal advice to both to people who ask us about what we believe can be excluded and what can be included. We try to be scrupulously fair and stand in the middle and not be appearing to aid either side. I believe it would be problematic for us to either get together with companies or with proponents in advance, because it would seem as if we would have already decided the issue before it's presented. We have to let each side advocate for their respective positions.
Yeah, but giving them the guidelines of how their proposal could be.
We hope our letter was clear on how they might work it.
Well, thank you. I'm a big advocate of your XBRL system, which companies file their financial statements in a standardized structure data format. And I believe it's the way of the future, and I must say that many of the companies that I'm privileged to represent are really thrilled that they can have a standard format and get the materials done each month and get the information back. And I think that you should be moving toward a structured computer readable financial statements. And where does this stand right now? My time is almost out. Are you doing an RFP? Are you developing this in-house? What data elements are you capturing in the XBRL system? And basically, what they're required by law to report to you, you're putting in a standardized form, so it's easier for companies and easier for you to understand and for the public to understand.
Correct.
Where does it stand right now?
That's what's required right now. The financial statements are required. There's a separate schedule that needs to be filed in XBRL that has the financial statements, and the financial statement footnotes need to be tagged so they're in.
Is it computerized and available now to companies, and is it available online to the public
It is.
that wants to study it? And
the XBRL data is available to anybody who wants to go online. The companies have to file it, and all companies.
Did you develop it in-house?
It was before my time. It was several years ago. I don't think XBRL is I think a relatively well-known computer technology that.
But the standardized format, so I'm being told by some companies, seems to be new. They feel that this cuts their paperwork and it makes it easier for them to file the changes that you've made. Anyway, thank you.
So it's an improvement. Great. Thank you. The gentlelady yields back. The Vice Chair of the committee is recognized for 5 minutes.
Thank you, Mr. Chairman. Again, thank you for appearing before our committee and your testimony, Mr. Higgins. As we discussed prior to your testimony, I represent Virginia's 5th District. It's a rural district. We have University of Virginia, which I know you're familiar with in our district. Access to capital is an extremely important object for me as a representative of a district where we have in some places where we have unemployment as high as nearly 10%. Job creation is sort of is the order of the day. That seems to me the most important thing facing my constituents, and capital formation obviously is an important part of that. Because of the University of Virginia, we have emerging growth companies that are coming out of the research that takes place there at University of Virginia. And I'm glad that Ms. Maloney mentioned XBRL, because that's something that from constituents that I've talked to who have had to deal with that system find it less than satisfactory and have real concerns about the cost and ultimately whether or not it benefits the investor in any way, shape, or form. So from the people that I talk to and from my constituents, we believe that it is not ready for prime time, although hoping that at some point that it will be useful to investors. But at this point that it's not. And so Representative Sewell and I have introduced legislation that would exempt emerging growth companies from those requirements, certainly until that time that it is a more useful program. But with that said, I know that the Jobs Act required the SEC to study the Reg SK. You all came back with a report, and that it sounds like Chair White has asked for follow-up. I think there were some who were disappointed that there was not more meat in the original report that was presented based on that. But I guess my question in terms of the disclosure issue, and XBRL is very much a part of that regime. I guess my question is as you all go forward looking at corporate disclosure, what are your goals and what are the timelines? And this is very important because I think there is a lot of concern about the pace at which these Jobs Act proposals have been implemented. What is the goal in your mind of this corporate disclosure project, and when can we see some results?
Well, it's hard to predict when we'll see results. What the division is doing right now is preparing, as the chair asked, preparing recommendations. We would expect that those recommendations would likely take the form of some sort of a release that could be exposed to the public, because although we think we're good at the division, no disclosure pretty well, we need to hear from companies, investors, market participants as to what it is they want, what it is that's burdensome, what it is that could be added to. There's a whole host of things that we need public input on. So we're moving on that. The next step would be to get public
How would you
input.
articulate the goals of, what were the goals? And again, if you could...
Our goal, as always, is to provide investors with material information on which they can make voting and investment decisions, and to make it as less burdensome on companies as possible to provide information. I mean, we know there's examples of information that's now required. You know, the historical stock price chart. The people don't go to the 10K to get a company's historical stock price. They go on Yahoo Finance or Google or something like that. So these are things that can be cut out. They'll be small steps. There may be bigger steps that can be taken. But our goal is effective disclosure. The phrase disclosure overload, to the extent that there is more disclosure than investors need, we don't think that that's right. There may also, in the process, we may find out that investors are looking for more, and we've already heard from some investors that they think disclosure can be enhanced on issues like short-term borrowings and the like. So our goal is to find the balance.
Well, and I would ask you to also consider this, that obviously these disclosure requirements, in addition to in many instances not providing useful information, efficient information to investors, they cost companies a lot of money. For an emerging growth company, those dollars could be put into research, into development, as opposed to something that's useless to investors and is not helping them at all. So I would ask you to obviously consider that as part of your goal. Thank you, sir.
Thank you.
The gentleman kneels back. Mr. Perlmutter, welcome
thanks,
to the
Mr.
committee.
Chairman. Good morning.
Good morning.
I'd like to first, if I could, introduce a letter to you and to Congresswoman Maloney dated July 23rd from the Council of Institutional Investors.
Without objection.
And then I'd like to yield the balance of my time to Mr. Scott.
Mr. Scott is recognized.
Thank you very much, Mr. Chairman. Let me ask you, I've got a couple of points I want to ask you, but first, now under Section 953B, corporate governance, the SEC is to come back with a rulemaking regarding compensation for top executive pay. And you have an October deadline of coming up with that rule. How are you progressing with that?
Right. Well, the 953,
yeah,
the CEO pay ratio?
Yeah, 953B, the Wall Street Reform Act, requires the SEC to issue a regulation mandating that companies disclose the ratio of pay between the CEO and their median employees. And we're trying to get at this. The whole issue now is fairness and equality in pay. And
the Commission issued a rule proposal last September on which we've received over 128,000 comment letters, 950 of which are unique. It is on the regulatory rulemaking agenda of the Commission for this fiscal year, which, as you note, has an October 14th deadline. But that was set back at the time. It is what the Commission thought it could get accomplished in that time frame. It wasn't determinative that there's no strict deadline on that. But it's a goal. The Chair has indicated she would like to get a final rule done on that this year, and we are working to develop recommendations for the Commission to make that happen.
Yeah, but do you feel right now you will be able to meet that deadline, or will it be an extension? I mean, I know there's been discussion.
Right. We are working hard on a recommendation for the Commission, which they could act upon during the course of this year. But I can't promise that the Commission. I can't speak for the Commission. They set their agenda. I can't speak for what their deadline will be on acting on that proposal.
Have you gotten tangible research as to how wide this gap is? Do you feel that this disparity is a crucial factor in the governance of corporate governance in your role? I guess what I'm asking is, does the SEC feel the sense of this wide gap within what top CEOs are making? And I don't at all deny people from making money. They should, certainly. But there's an issue is this grasp for this money way at the top of the corporate structure detrimental to this disappearing of the middle class?
mean, I'm not sure that the Commission has a view on that. What the Commission I think has a view on is that Congress enacted 953B, directed the Commission to adopt rules. We are working to get those rules done, as we are with all of the mandated rulemakings that we've been.
And so you're aware, I mean, it's a part of the law, it's there, and we can expect the SEC to come forward with that rulemaking.
It's a mandate of Congress, and we take it seriously.
In my opening remarks, I did touch upon the cross-border, and I want to rectify my comments on that. My understanding is that we just passed the bill, which is the FCC reauthorization, that does require you and the SEC to issue a joint rule. This is very critical as we move forward because it involves an international situation. Swaps and derivatives are now a growing part of the world economy, $800 trillion of the world economy. So in that light, could you just tell me if there have been any discussions going forward within the SEC in reaction to House Resolution 1256, where we incorporated that requirement in that you and the CFTC come up with a harmonization for cross-border? And in the reauthorization.
The cross-border swap area is not part of what the Division of Corporation Finance does. It's our trading and market.
Yeah, I understand that, but
I'd be happy to have someone get back to you on that, but it's not anything of which I can't speak because I simply don't know.
Okay, I just wanted to clear that up because I might have misspoken in thinking that you did qualify that, but that is a great concern to many of us on both the Finance Committee and the Agriculture Committee, and we haven't heard anything from the SEC.
So we can follow that up maybe in your next 5 minutes.
I'd be happy to follow up.
Mr. Royce, recognized for 5 minutes.
Thank you, Mr. Chairman. Again, as it relates to insider trading, as I mentioned in my opening, take, for example, a company that seeks to purchase another firm. We call the other firm the target. The company enters into a contractual relationship with a hedge fund to purchase the shares of the target for the benefit of the company before the announcement of the intent to acquire the target. The company and the hedge fund basically call their agreement a joint venture, or they call it a partnership. Does the existence of the contract somehow make what would otherwise be illegal trading by the hedge fund in the target company's stock legal insider trading?
Congressman, I obviously can't speak to any particular situations, but in general, there's, and I would also say that it's really the Division of Enforcement that handles insider trading.
Sure.
But I'm familiar with the law in the area. There's two rules under the Commission's jurisdiction that address insider trading. The first, Rule 10b-5, requires, in order for someone to be liable for insider trading under 10b-5 based on Supreme Court precedent, there must be a breach of some duty owed by the person trading to the source of the information. In the instance that you cite, if one company brought another company in, said, let's work together, I want to take this company over, I'll let you in on it, that wouldn't be any breach of any duty.
But let me throw in one other factor for your consideration before we get to the other caveat. Okay. What if the company had taken steps towards a hostile deal before entering into the agreement, and the company and the hedge fund's interests were not aligned under the terms of the agreement?
Right. Well, on the taking substantial steps, the other insider trading rule is 14E3, which deals with tender offers. And when a bidder has made taken substantial steps to commence a tender offer, anyone who gets material non-public information from that bidder who trades on it is liable for insider trading, irrespective of any breach of a duty. So that's how 10b-5 and 14E3 work differently. I'm not sure I completely understood where the one person might be working at counter purposes to
why they wouldn't be aligned. In my view, they wouldn't be aligned because one party can walk away from the transaction at any time. The other party, the hedge fund, clearly is now tied into the agreement, is benefiting from the rise in the stock price as a result of the rumor being driven of the hostile takeover, right? So these interests are not, in fact, aligned.
Yeah, I mean, it.
And I'm also I'm also confused as to how this is any different than a couple of buddies out on the golf course. Something we've seen a lot about. You know, something you've seen a lot. Exchanging information. Are not sellers of the target's shares subject to the same imbalance of information as investors in a stock that is victim to a traditional insider trading scheme? I'd assume the fraud is the same regardless of the structure. And does this somehow, labeling this buying scheme a joint bid, insulate it from insider trading charges? That's my concern.
And that's a question that I don't think that either the Commission or the courts has answered on whether two parties getting together constitute co-bidders and
I'd also like to know what the SEC's process is for examining a novel or a creative deal structure, and what are the SEC's options to investigate conduct related to these types of transactions?
Well, if a filing comes in to the division, it would come in typically to us, either a proxy solicitation or a tender offer or a merger. We have criteria that we use to screen it if it meets the criteria, and we would look at it. And typically, hostile deals tend to meet our criteria for screening. We would look at it. We'd provide comments. We would review it against the applicable disclosure requirements as well as the anti-fraud provisions of our laws. Make comments to the participants and work through those, so that the goal always being that investors get clear, accurate, material information.
Thank you, Mr. Chairman.
I thank the gentleman. Mr. Scott, who is recognized for his second 5 minutes.
Thank you, Mr. Chairman. I yield my time.
Oh,
do you want my time?
no, actually, it's. I think
Okay.
we're just going down the row. You have not had your time, I don't believe.
Do you want my time? Do you want my time? I don't need time. You want it? Mr. Chairman, I'll yield my time to Mr. Peters.
Okay, so there we go. Mr. Himes is recognized. He's giving it to Mr. Peters. Mr. Peters, you recognize.
Thank you, Mr. Himes, and thank you, Mr. Chairman, for that. I appreciate it. Hi, Director Higgins. It's great to have you here. And as you're here, I'd like to briefly discuss some legislation that I've introduced last year and ask you a couple questions following that would amend financial disclosures of publicly traded companies. As you know, publicly traded companies must disclose certain information in registration statements, prospectuses, and other periodic mandatory filings, including a general description of the company's business, a description of the company's principal products and services, and a description of the company's subsidiaries. Companies must also disclose the total number of employees that they have and anticipated changes in the number of employees working in various corporate departments. While corporations must disclose their total number of employees, they do not need to disclose where they are based. Elimination of 700 jobs in the United States, for example, and the creation of 1,000 jobs abroad, in China perhaps, would register only as a net gain of 300 jobs. I believe responsible investors have a right to know how publicly traded corporations are spending their money and whether they're hiring and investing in the United States or sending earnings overseas. Where companies are hiring or laying off employees could be determinative, and it could be material information, certainly for potential investors. My bill, the Outsourcing Accountability Act, will simply add location of employees to the annual SEC disclosure requirements. News reports would need to disclose the total number of employees in the United States broken out by state, as well as the total number of employees abroad broken out by country. The SEC would be given the authority to issue regulations to implement this measure. And finally, the bill would harmonize with the Jobs Act by exempting companies for the first 5 years after their IPO to avoid increasing compliance burdens on newly public employees. So, Mr. Higgins, although I have introduced this legislation to require this disclosure, do you believe the SEC currently has the authority to implement this proposal through rulemaking and without congressional action?
Does the Commission have I believe the Commission would have authority to implement, to adopt a rule such as that, even absent a congressional mandate.
Okay, good. Do you believe that disclosing the physical location of employees would impose less of a burden on companies than disclosing the median of the annual total compensation of all employees of the company and the ratio of that median to the annual total compensation of CEO, which was a rule proposed by the Commission just last year, as you know?
I don't really have any sense of, I mean, we don't have information on what it might cost to do it. Just off the top of my head, it seems less burdensome, but without actually getting information from participants, from the companies that actually have to prepare this information, it would be hard for me to speculate.
Although obviously the calculations involved in the rule you did last year are fairly involved, it would certainly be reasonable to think that a company would be very easy for them to know where they send their paychecks every month. That's information that's probably just a button away.
Right.
Is that an accurate statement, sir?
That seems right to me. Yeah.
Great. And given this change is straightforward and certainly is not particularly complex, I think, given the fact that the company certainly should know where they send their paychecks every month or however often they pay, do you believe the SEC has the capacity to implement this proposal without difficulty?
Well, if Congress passes a law, the President signs it mandating that the Commission adopt rules, the Commission will proceed to do that. What we would do as we do with any rulemaking is that we would have our economists looking at the costs and benefits of such a rule. We'd put it out for notice and comment rulemaking so that we could get public input from companies, from investors and other market participants as to their views on the rule, and we would take that all together in fashioning final rules. But I don't see any structural or other impediments to adopting a rule such that just as long as we have enough time and ability to attend to it, and we have a pretty full rulemaking calendar.
Right. I realize that. Well, thank you, Director Higgins. I appreciate that. Mr. Chairman, I yield back.
The gentleman yields back. We now turn to Ms. Wagner for 5 minutes. The gentlelady is recognized.
Thank you, Mr. Chairman. I thank Mr. Higgins for being here also. In your testimony, sir, you indicated that you all are seeking input from a broad range of companies, investors, and other market participants. What does the division plan to do to address the 43 remaining recommendations of the SEC's Forum on Small Business Capital Formation?
Right. Well, we do every year have a government small business capital formation forum. We get input from the participants there. They put together recommendations. We, as you know, we received 43 recommendations this year. I think it was interesting to us, none of them had a high priority attached to them. All were either medium or low priority. But that's okay. I mean, obviously the ones at the medium were the ones we should be looking at first. Of the top 10, I think about 8 or 9 of them dealt principally with existing rulemaking proposals that the Commission has already, most with either crowdfunding or Reg A+. And so with those, we're taking those into account as we work through to get a final rule proposal on those rules.
In the past, Congress has had, I think, very little insight into the SEC's process. And here I'm talking really about process for evaluating the Small Business Forum's recommendations. Do you, in fact, have a process, and would you be willing to work with the committee to make your process a little more open or transparent?
We would be. We do have a process. We work with the forum. We get the recommendations. We put a report together on what the recommendations are, and to the extent that we have the opportunity to talk to the Commission to see if they want us to pursue those, it's something that we would pursue.
Well, and we'd, as I said, would love to be brought into the process more, so I think it's a little more transparent, and I'm wondering if you're willing to allow us to do that. It might help in prioritizing some of the legislation and policy we put forward.
We're happy to work with the committee on any matter.
Great. Mr. Higgins, angel investors such as St. Louis Archangels in my district are creating jobs across the nation with their investment in startups. What is the division doing to make sure that any rules under consideration do not hurt angel groups or harm the prospects for high potential startups across America?
Right. I mean, we don't single out angel groups as a favored group, but we look at how our rules affect, or our proposed rules affect all groups. In angels, in particular, what we've attempted to do, we realized that after the general solicitation rules came out, there were questions that came up about how that affected angel investing.
Correct.
And what we've attempted to do, we put out staff guidance on issues that we think can be helpful to.
And have you received feedback on your report or your guidance that has?
We have, and I think it's been favorable. I spoke last fall at the they had an angel convention here in Washington, D.C. I spoke to the group about the things that we were doing, and I think we got very positive feedback. And
Mr. Higgins, regarding the Jobs Act, an unfortunate oversight left savings and loans out of these provisions. To fix this, I introduced the Holding Company Registration Threshold Equalization Act of 2013, along with Representatives Womack and Himes and Delaney. It passed the House by an overwhelming majority of 417 to 4. Mr. Higgins, what is the SEC doing to fix this issue?
We are currently working on the 12G Title V, Title VI rulemakings right now, and that is an issue that is among the issues that...
Any time frame, sir?
Sorry, we would hope to have... We're hoping to have a proposal out this year, but
Okay, great. Thank you. Question. Since 2008, the Small Business Capital Formation Forum has recommended that the SEC change its rules to permit forward incorporation by reference in registration statements on Form S-1 by all companies. The forum said that the current rules are an impediment to capital formation and adds little or nothing to the availability or quality of subsequent public information. We've had witnesses come before the committee who've crossed the ideological spectrum who've said the same thing, and that the change is long overdue. What is the division doing to remove this unnecessary impediment that adds little or nothing to investor protection?
Right. Well, we don't have any current rulemaking project on that right now. If we were to look at the question, I think what we'd want to look at is forward incorporation has historically been eligible for companies that have had a market following for some period of time. And so we'd want our economists to take a look at how information gets disseminated by companies that don't have as big a market following as some others. But it's an issue that we do understand.
And take very seriously. I've introduced the Small Business Freedom to Grow Act, and it includes this recommendation, and it passed our committee by a large bipartisan vote, so I'm hoping it will be coming to your attention very soon. I thank you, Mr. Chairman, for your indulgence, and I yield back.
Thank the gentlelady. And now we talk to Mr. Foster for 5 minutes.
Thank you. I'd like to ask a few questions about the conflict mineral disclosure rules. Although Section 1502 requires mandating disclosures by publicly traded companies of the origins of listed conflict minerals, because of complex products and complex supply chains, many private companies that supply components to these publicly held companies are also effectively covered under the rule. In fact, there's a private company in my district that's been grappling with the costs associated with conducting due diligence as required by this rule. And in correspondence with my office, they noted that they have been soliciting mineral information from their suppliers both in the United States and the United Kingdom, but they've received very low response rates. And this has led them to expend many hours and many of employee time and many resources trying to follow up with these suppliers. So I had several questions related to this. First, in light of the D.C. Circuit striking down a portion of the rules requiring issuers to describe certain products as having been, quote, not found to be conflict-free, is there a clear definition of what would satisfy the due diligence requirements on the Form SD? Should they simply, rely on their suppliers and their responses as truthful? Is there a de minimis level of component value at which they can say, okay, we'll just take your response at face value and not have to delve further in?
The rule does not have a de minimis
okay.
aspect,
so all the way down
aspect to
zero.
it.
So some microscopic component in a subassembly has to be documented as being conflict mineral free.
That's correct. The obligation of the public company to due diligence under an internationally recognized due diligence framework to find out, to try to assess where the mineral came from.
Do you think that might be a useful addition to this?
I'm not sure what would.
Well, it would just say that any component that is costs less than 1 penny, or is less than 0.1% of the total value of what it is that you're supplying to a publicly held company.
Congressman, I wasn't at the commission when the conflict mineral rule was being developed and adopted, but I do know that there was a lot of comment back and forth on the de minimis, on whether there should be a de minimis requirement, and the commission concluded at that time that there should not be consistent, and that was consistent with what they believed, I think, congressional intent to be on that. So whether that's an issue that should be revisited, I don't really have a view.
Okay, yeah, and so that's it. And the other thing is, at what point do you just take your supplier's word for it? You could easily imagine that you get in a situation where you go down your supplier's list until you find the first one willing to lie, and then that's it. And then what are the requirements, for example, for a privately held corporation to look look behind the scenes on each one of their suppliers?
Right.
I'm calling for some clarity as to what the definition of due diligence is, which at least the companies in my district that have contacted us on this don't feel that they know what the real definition is.
Right. Well, the rule is new. Obviously, this was the first year that it was mandated. As with any new rulemaking, perhaps we'll get feedback from suppliers like the one in your district, as well as other companies, that will inform our taking a look at whether something can be done to provide better guidance.
And what are the SEC's plans for enforcement against companies whose reports are deemed to be incomplete on this?
Right. Well, as with any new rulemaking, what we typically do is we will look at the forms, the reports that have been filed, to determine whether there's any general problem, whether companies are generally not getting the rule correctly. And if that's the case, we typically would issue guidance of general applicability. As to the review of individual filings, if in the course of a company's Sarbanes-Oxley 3-year review, if the staff were to determine that the company had an incomplete filing, it would likely issue a comment.
Right. So, but you would only be acting against the publicly held company and not their private subcontractor.
Correct. That's the only one who's subject to the rule.
Okay. And let's see, in my last 15 seconds, just a quick question that you may have to follow. In this issue of calculating the ratio of CEO pay to median income, a lot of the complexity is just if calculating the exact median salary is in principle a pretty complicated and computer-intensive job. You need like a list of all salaries, which may or may not be a big issue. But if there was if you could get back to us whether a simplification, for example, if you had an answer which was accurate enough to 10% in the median, if that would be a significant simplification, I'd be very interested in maybe Congress could take action there.
We can get back to you on that.
Thank you. Mr. Huizinga is now recognized for 5 minutes.
Thank you, Mr. Chairman. I appreciate that, and I actually want to continue to explore a little bit what my colleague from Illinois was talking about, because I too am running into manufacturers that are very much struggling what to do and how to handle conflict minerals part of the requirements in Dodd-Frank. And I actually would love to work with Mr. Foster and others if we can find some legislative resolution to this, because as I think he had mentioned, the D.C. Circuit Court of Appeals, the ruling, certainly adds a fog to this whole issue. And I'm curious, from your opinion, I mean, do companies need to comply with the conflict minerals rule in light of that ruling?
We think they do. A portion of the rule was struck down, but a substantial portion of the rule was upheld, and the Commission process in adopting the rule was upheld. And so the Commission made the determination that the rule, which Congress had mandated that we adopt, was upheld, and we needed to go forward with implementing.
Well, I, like you, wasn't here when they wrote Dodd-Frank. I'm just dealing with the echo effects of it, and this is a rather large echo effect that I think is
while obviously well-intentioned, nobody wants to see atrocities anywhere, and this was specifically geared towards the DRC, the Democratic Republic of Congo. But I guess the question is a couple of questions. Will you all review the guidance and clarify it for these companies?
Well, if there's a way that we can clarify what the private supplier's due diligence obligations are, we'd be happy to take a look at that. This is the first time that I've personally heard of the issue. Again, it's the first year of implementation, and we'll be happy to.
Well, and I'm concerned, I guess, philosophically, we're on a little bit of a slippery slope here as well, using securities laws to battle societal ills here. And even Chair Whitehead, I have a couple of quotes. She had questioned whether, quote, using the securities laws and the SEC's powers of mandatory disclosure, end quote, to accomplish what many deem laudable goals, such as improving mine safety and those kinds of things, and the human rights atrocities that are there. I mean, is it the proper role of the SEC to go in and try to correct these things, or is that, I mean, give me philosophically, I mean, what do you
My
think your role
philosophical
is?
answer is, it sort of goes back to my junior high civics class, and that's when Congress passes a law, the President signs it into law, and directs an agency to adopt rules. That agency should adopt the rules.
I got it. Okay, so you're executing your job as instructed. I understand that. I guess it's up to us, and in fact, I've mentioned this to the chairman as well. I think it would behoove us on this committee, and I happen to be vice chair of the Monetary Policy and Trade Subcommittee, to go see it for ourselves. And we've had some hearings here with folks from the Congo, with mixed reports at best as to the effectiveness of this, and as to whether we are actually maybe even causing more harm to the localized economy. And I'm not talking about to warlords and to others that may be controlling the area. I'm talking about for the real people that are dependent upon those jobs and on the mining that is there. So. I've got not quite a minute left. I know another one of my colleagues was talking a little bit about the pay ratio, and I think that was the quote was getting at the fairness issue. Do you believe that anywhere in this 953B does it fit within the SEC's three-part mission of protecting investors, maintaining fair, orderly, and efficient markets, and facilitating capital formation? Is that the job of the SEC?
That is the mission of the SEC, as many people have said here today. I guess I'd turn again on 953B. As Congress directed the Commission to implement.
I know you were directed to do that, but the question is does publishing pay ratios, which there's no guidance as to whether it's part-time, foreign, contracted out to get the bathrooms cleaned, is that really going to maintain fair, orderly, and efficient markets, facilitating capital formation, protecting investors? I'm lost as to how that actually happened.
I mean, and as to it, what my personal view on it, I'm sorry to say, is I think irrelevant to what the mission of the Commission is to follow the law.
I get it, and you're doing that well, and we could keep talking until the chairman notices that I'm over my time. But I'm rather enjoying this. So I guess I would express to my colleagues that we have a role here, and the SEC has a role here, and I'm not sure that that is executing that. So, thank you, Mr. Chairman. Appreciate the additional time.
It was such very important discussion that was going on by the gentleman, and I believe it was being receptive by both sides of the aisle, that I wanted to give you the latitude there to go on. So thank you. And with those extra seconds in mind, the gentleman from California is recognized. We'll be looking for equally insightful comments too.
Well, one insight is that the job of the SEC is to carry out the statutory mandates that we pass in Congress, that we impose on the SEC. It's not just their job to protect investors. We've assigned them, through statute, an effort to try to diminish the harm done by conflict minerals, for example, or to try to illuminate for this country the growing gap between CEOs and medium pay. If tomorrow we pass a statute because we conclude there's a surplus of green paint in this country, that everything at the SEC has to be painted with green paint, then that also becomes part of their mission. Let's hope we don't have such an enormous surplus. Speaking of the pay disclosures, when are you going to get the job done?
Right. We have active rulemaking projects on all of them. CEO pay ratio, we have a proposal out. The other ones we are working on to get recommendations.
Well, when are you going to get it done?
Unfortunately, I don't control the agenda. The Commission has a lot.
What's your best estimate as to when it will be done?
I just don't really have an estimate. We'd like to get it done because I'd like to get it done. Get it behind me. It's a mandate that we need to get done.
Will it be done a year from now?
I can't predict.
Will it be done 2 years from now?
I just can't predict.
10 years from now?
I won't be in the job, but I don't.
But sitting where you are now as the best person to predict whether it'll be done 10 years from now, will it be done 10 years from now?
Yeah, confident of that.
Oh, 9? Let's see. Well, let's focus on the accounting issue. Has your division or the SEC in general looked at the economic harm and unfairness of the lease accounting proposal pending at the Financial Accounting Standards Board?
Dealing with the FASB is the role of the Commission's Office of Chief Accountant.
Right.
And the Chief Accountant doesn't report to me, but I'd be happy to have the Chief Accountant get back to you on what they've done on the lease accounting standard.
Do you have a Chief Accountant?
Well, he's announced that he's leaving, but we still have a Chief Accountant.
I know. I called over there. He wouldn't talk to me on the theory that he was packing his bags. So your optimism that the Chief Accountant will get back to me on that...
I'm sure that someone can get back to you, Congressman.
They did. They didn't say anything, but they did call back. The box was checked. Okay. What, under the conflict mineral rules, if a non-public company simply lies when it's a supplier to a public company, are they subject to any criminal penalties or anything else?
Criminal penalties? I don't know the answer.
Is there any, assuming you're really good at lying, is there any reason for a supplier not to lie and just say, hey, no conflict minerals here?
Yeah. Well,
if they do that, what penalties do they face? If they're non-public.
The public company has an obligation to conduct reasonable due diligence, and if there are no red flags around that lying, I would assume that the public company could rely on that information.
So if the supplier is able to lie with the effectiveness sufficient to fool the duly diligent, they're home free.
I don't know what the consequences are of a private supplier lying to a public company in satisfying its diligence obligations, but I can look into it. I just don't know the answer off the top of my head.
Finally, as to computerized trading, they're taking money off the table. They're not performing any service to the economy that I can ascertain. We got a flash crash. What is the benefit to our society and to our markets to allow to not having taking any one of several steps that would minimize this computerized trading?
Right. I don't know whether you were here for the hearing where Mr. Luparello, who's the head of the Trading and Markets Division, testified, and whatever answer he gave you would be my answer, because it really is in his area and not mine. I just don't. Our division doesn't deal with high frequency trading.
Yeah, I'm looking at the SEC chart, and you're one of like 30 boxes, so it's hard to know which 1/30th of the SEC's responsibility we're addressing here today.
Sorry.
But it's nice to know that my part of addressing it has concluded. Thank you.
Indeed. Mr. Mulvaney is now recognized for 5 minutes.
Thank you, and I appreciate the questions by Mr. Foster from Illinois, Mr. Huizinga from Michigan for taking that opportunity to remind us all that the SEC is in charge of regulating conflict minerals. As someone who's still fairly new to the committee and still fairly new to Congress, I hope that still strikes some people, in addition to myself, as just patently absurd, that the Securities and Exchange Commission is in charge of regulating conflict minerals, that an entity that is supposed to protect investors, maintain fair, orderly, and efficient markets, and facilitate capital formation is in charge of making sure stuff doesn't come from the Congo, a country, by the way, just ironically, that also receives taxpayer subsidies from the Export-Import Bank, another topic that we'll be taking up shortly. And for folks who follow the markets and who rightly will ask the next time that an investor is damaged or injured, that markets are not fair, orderly, and efficient, or that capital formation has been somehow impaired, and they ask the very reasonable question, where was the SEC? Why weren't they doing their job? The answer will be, well, they were doing their job. They were making sure that we didn't have stuff coming in from the Congo. And they're doing that job because we told them that's their job. And I hope that I'm not the only person who thinks that that is just one of the craziest things I've heard since I've been in Congress. It is relevant to what I want to talk to about, Mr. Higgins, because I take the opportunity whenever I can to talk about the Jobs Act, to talk about specifically crowdfunding. And it continues to sort of stick in my craw that we have rules on conflict minerals, and we got those in a very timely fashion, but we're now 18 months late on some of the crowdfunding rules. The Reg A+ rules are also late, and that it seems like, at least for some of us, the priorities are a little bit out of whack. Again, I'm not blaming you, but to have conflict mineral rules before we have crowdfunding rules seems to me to be a case of misplaced priorities. Let me ask you about some of the proposed rules, because the SEC does have some proposed rules floating out there regarding crowdfunding. And I want to dig down on some of the places where I want your opinion, sir, as to whether or not how you think these proposals will affect capital formation, specifically the rule that if I'm going to try and raise more than $500,000 through crowdfunding, I have to get an audit. I have to have audited financial statements. I used to run a small company. Audited financial statements are very, very expensive. In fact, we rarely audited. We had reviewed, but not audited financial statements. Do you think, sir, that that requirement will positively or negatively impact the ability of small businesses to access capital through crowdfunding?
Well, it's a question that the Commission has asked in the rule proposal. It's set, Congress had set the $500,000 threshold for audited financial statements, but gave the Commission the ability to change that and raise it up to $1 million. The Commission stuck with the $500,000 in the proposal, but asked for comment, and we've received comments from a variety of people saying, yeah, $500,000. Some people want it lowered. Yeah. Other people want it high. So these are comments that we are considering as we prepare a final rule proposal.
But I think you'd agree with me that it might make it less likely that businesses would access crowdfunding if they have to go through the additional cost and time of having audited financial statements.
I don't know that, but I do know that audited financial statements cost more than reviewed financial statements.
Gotcha. Also, one of the proposals is that these businesses follow the generally accepted accounting principles. They follow GAAP. Similar impact there to the audited financial statements requirements?
We're getting comment on that as well. I guess a GAAP is establishing now a private company financial statement regime, which would be different than GAAP. We're getting comment on that. I think our Office of Chief Accountant is helping us think through and analyze that issue. But GAAP is pretty well known. I guess as to opposed to what, a cash method or an income tax or something like that, although at the lower levels I think some of those suffice.
And finally, Mr. Higgins, on the proposed rule regarding only using a single intermediary, is that something you all continue to look at as opposed to allowing businesses to use multiple intermediaries?
We are. I mean, and we've gotten comments on both sides of that. Some people saying that a single intermediary focuses the protection better. Others think that it might limit the ability for companies to be able to raise money.
Thank you, sir. And since we mentioned GAAP, let me change gears on you for just a second, because we had Chair White in May giving a speech explaining that she wanted to use international financial reporting standards more aggressively in the future. And I wonder if you have an opinion, sir, as to whether or not that, using the IFRS in our capital markets, might create a confusing situation where we sort of have two competing systems at the same time, a double gap, so to speak.
Right. Well, I think what the Chair, I believe the Chair's position on IFRS is that she would like to get a sense of the path forward by the end of this year, I think is what she said publicly. And on whether it causes confusion. Currently, foreign issuers are allowed to file under IFRS. There's no GAAP reconciliation required. I think the Commission is committed to a high-quality set of global, accounting standards. If IFRS turns out to be that, I think that would be probably going, the direction to go. On the other hand, there's a lot of debate going on whether that's the right direction, and I think the Commission is trying to sort through what the path forward will be for U.S. companies.
Thank you, Mr. Higgins. Thank you, Mr. Chairman.
Mr. Lynch? Sure. Is recognized for 5 minutes.
Thank you, Mr. Chairman. I appreciate that. Thank you, Mr. Higgins, for helping the committee with its work. I would like to ask, Mr. Chairman, unanimous consent. I have a report here by the Council of Institutional Investors relative to the oversight of the FCC's Division of Corporate Finance.
I understand that it's already been entered. So
I'm sorry?
Already been entered.
Oh, thank you.
But with the unanimous consent, we'll do it a second time.
Thank you, sir. Mr. Higgins, I'd like to talk a bit about WIXI waivers. As you know, the well-known seasoned issuer waivers are something that the Division of Corporate Finance controls. The Director controls that. And just to clarify, the WIXI label enables a well-known seasoned investor to use automatic shelf filing rather than going through the whole detailed filing with the SEC. Automatic shelf registration, I think it's called. Mm-hmm. But what is problematic is that the SEC and Congress, through regulation and through the laws, have basically prohibited in certain instances companies from using that label or designation if they've been found guilty of serious felonies or in some cases misdemeanors. And those measures are intended to protect investors in the markets from bad actors. As I said, under the federal securities law and regulation, issues are automatically disqualified by Congress or the SEC from claiming WIXI status when they or their subsidiaries are, among other factors, convicted of certain felonies or misdemeanors or are determined to have violated the anti-fraud provisions of the securities law. However, in practice, the SEC frequently waives these disqualifications, allowing issuers to claim the benefit of WIXI status. Since 2010, the Commission has granted at least 30 WIXI waivers, and I guess not surprisingly, 29 of those waivers went to very large financial institutions and broker-dealers. In many cases, these issuers are receiving their second, third, even fourth WIXI waiver in less than 4 years. And as SEC Commissioner Cara Stein notes in her recent dissent from the SEC's waiver for the Royal Bank of Scotland, some large firms have received more than a dozen waivers over the past several years. One large financial firm alone, in a 10-year period, received 22 different waivers from the SEC. So that is problematic. I agree with Commissioner Stein's remarks that nearly every factor in the Division of Corporation Finance's revised statement on well-known seasoned issuer waivers weighs strongly, I think, especially in the case of a waiver for the Royal Bank of Scotland. The egregious conduct by the Royal Bank of Scotland was part of a widespread scheme undertaken by a number of large banks to manipulate the LIBOR rate for their own profit, and the LIBOR rate is You know, it's determinative for $350 trillion in derivatives. It basically underpins the entire U.S. derivatives market. So by manipulating LIBOR, those banks were manipulating the entire U.S. derivatives market. And the manipulation of LIBOR by the Royal Bank of Scotland harmed millions of Americans. The Royal Bank of Scotland did this at a time when our nation was facing its worst financial crisis since the Great Depression. We didn't get much action here in Congress over this whole scandal. I don't know how that happened, but we had very, very little attention on this committee with respect to the manipulation of the LIBOR rate. In such situations, the SEC needs to ensure that the American people are protected from egregious conduct by financial institutions, and the SEC should be penalizing the Royal Bank of Scotland for its conduct instead of granting them a waiver. And I just want you to persuade me that I'm wrong here.
Well, the WIXI status that you refer to, when a company is convicted or one of its subsidiaries is convicted of a crime or an anti-fraud violation, it automatically disqualifies them from WIXI status. The rules that the Commission adopted build in a waiver process if, for good cause shown, the issuer shows good cause why the waiver shouldn't apply. The focus of the inquiry is whether the conduct for which the issuer has already been punished. I mean, it's not a question that...
How are they punished?
I think they paid a multi-billion dollar, I mean, it was a significant, no, it was in
so
the
you can
hundreds of
pay your
millions.
way out of
that's what the Justice,
I mean,
that's what the Justice
That's being
Department,
paid in many cases by the investors.
Right.
So the people who have perpetrated this are not getting penalized. The investors are getting penalized with the fine, and that's it?
Right. The WIXI disqualification was never considered by the Commission to be a penalty for the underlying conduct. What it was is an automatic disqualification because it called into question whether the issuer could produce reliable, accurate disclosure. It might. And if an issuer could show, with good cause shown, that it didn't affect, that conduct was unrelated to their disclosure.
But you get one company here 22 times. At one point, you know, I know you could say it's anecdotal, but at some point it becomes a pattern in practice.
With that.
Thanks for your indulgence, Mr. Chairman.
Sure, thanks.
Thank you, Mr. Higgins.
Thank you.
Mr. Stivers, for 5 minutes.
Thank you, Mr. Chairman. Thank you for being here, Mr. Higgins. I was just looking at some speeches by some of the members of the SEC, and in October of 2013, Chairperson White essentially talked about how increasing the disclosure regime can lead to information overload. I looked at another speech that Commissioner Gallagher made in July of 2013 that talked about when you require too much disclosure, it really is becoming a regulatory creep and doesn't provide real value to investors. And then a speech by Commissioner Pivovar in January of 2014 where he again expressed concerns about the continual growing disclosures and how it leads to information overload. And then I looked at a speech you made in February maybe or April that says, and I'll quote a little bit of it, while it may be called disclosure overload or cutting the clutter, losing the excess baggage, we can all probably agree on the need to reduce immaterial disclosures and ... However, essentially you say that one person's meat is another person's fat. Well, I guess my first question is, you do work for the commissioners, right?
I do.
Okay. So you do share their belief that there could be some information overload in the disclosures or not?
I believe that there could be disclosures that investors don't find useful and the companies find burdensome. I also believe that it could go the other way. There could be information that isn't there that investors would find useful, companies may find burdensome, and the job of the Commission is to balance that.
Right. And so my next question is, what are you doing about it?
Right.
How are you reaching out to figure out what disclosures are overly burdensome to companies and not useful to investors? And and even to find information that would be useful to investors that's not included in disclosures. Although if everybody's talking about disclosure overload and mission creep, my guess is there's a lot more that you might be requiring today that's not useful to investors as opposed to stuff that's not. But what are you doing about it? How are you fixing that problem and seeking information?
Right. We've reached out to a lot. First of all, people can send us in a disclosure at sec.gov. They can send in their recommendations, their comments, their thoughts about how we can get better, more effective disclosure. We've gone out, we've met with interested groups of investors, companies. I spent some time at a large mutual fund complex speaking with portfolio managers and equity analysts about information that they find to be useful. And it's eye-opening. These folks at big financial institutions want more information. They'd like to see companies.
And big financial institutions have a lot of means to get their own information. Your job isn't to work for big financial institutions. Your job is to protect investors. And so, is your job to substitute for their own due diligence?
Not at all. Our job is to make sure that investors have the accurate material information necessary to make voting and investment decisions, and that's the input we're seeking.
Great. Well, keep seeking comment and information and then act, because I do find the SEC seeks information a lot. Acting is sometimes slow, and I share that frustration with, and I know your commission, it's not like there's one person directing you, I got it. There's variety of opinion, but I just read 3 of the 5 commissioners who have a fairly similar position, but keep seeking information, but then at some point, please act. I'm running out of time. I do want to ask you about, every year you get recommendations on capital formation from your Small Business Capital Formation Commission. Tell me, how many of those have you acted on?
Right. Well, if you're referring to the Government Small Business Forum.
Yeah, the Small Business Forum. I'm sorry. Have you acted on any of their recommendations?
We have acted on recommendations.
Do you have any idea how many? Do you know the percentage?
I don't, but we can certainly
get back to me on that.
And a lot of those recommendations actually became part of the Jobs Act, and
right.
we're acting.
And you know why they became part of the Jobs Act? Because the SEC didn't act on them. So, I mean, that's my push here, and I have 8 seconds left. But, you've got a great advisory council of small business people that are telling you the things they need and the burdensome things that are weighing on them. Please listen to them. That's my plea to you.
Thank you.
I yield back, Mr.
Gentleman yields back. Carney, for 5 minutes, is recognized.
Thank you very much, Mr. Chairman, for having this hearing. Thank you, Mr. Higgins, for coming in to help us do our important business. Yesterday, we had a hearing before the full committee with a great panel, which included our former chairman and ranking member, Barney Frank. And we had a lengthy discussion about risk retention in mortgage lending, securitization and mortgage lending. Under Section 941 of Dodd-Frank, there was a requirement that the SEC, along with the banking regulators, with HUD and with the FHFA, prescribe rules about risk retention, not less than 5% of an economic interest in a material portion of the credit risk for any asset that a bank might transfer. And of course, you came out with a rule, or the agencies came out with a proposed rule in March of 2011, and then a re-proposal in August in 2013. And the issue that former Chairman Frank complained about was the fact that the original statute, as he described it, and I have his testimony here, said that there are 3 categories of mortgages: those that fell below QM standards, which were subject to certain legal constraints; QM mortgages, which were the minimum standards; and then QRM, which were the super good quality mortgages. And that in the re-proposed rule, that the Commission and the agencies, I should say, came out basically where QM and QRM were essentially the same, thereby, according to former Chairman Frank, taking out the risk retention provision because some of those QRM mortgages are not subject to that. What was the thinking from the SEC's perspective of that re-proposed rule vis-a-vis risk retention? and in the mortgage lending space?
Well, the reproposed rule proposed that QRM equals QM as
Right.
the preferred approach, but also offered an alternative approach which would have added additional features to QM in order to get to QRM, seeking comment, recognizing that it was an issue of substantial concern.
How would you respond to the former Chairman Frank's objection that the clear statutory intent was to have three categories, if you will, the non-QM, the lower standard, the QM minimum standard, and the QRM super quality, if you will, and therefore the QRM subject to certain exemptions under the Act or under the reg.
I think that's a view that's been expressed not only by former Chairman Frank, but by many commenters who have written in on the joint agency rule proposals. We're working through those comments. Joint agency rulemaking it's an interesting process. Because,
difficult.
Because you've got different agencies with different missions. The Fed's mission is different than HUD's mission, different than the SEC's mission, and so.
So we'll see what happens from there based on public comment. Lastly, in the last minute and a half, my friend and colleague Mr. Fincher and I worked in the last Congress on the IPO on-ramp. You may be familiar. It was a part of the Jobs Act. Didn't require any rulemaking, I don't think, minimal maybe. I wonder if you could comment on the success or what you've heard about some of the on-ramp provisions. And the one I'm most interested in is the quiet period, if you will, prior to an emerging growth company deciding whether to go public or not. They're able to issue reports, research reports to potential investors to gauge interest confidentially, not publicly, and whether or not. What I've heard from companies is that's very helpful because they don't
testing the water. This is the testing the waters provision.
Correct. That's correct.
Okay. Yeah. This was an area that I practiced in. I was in private practice for 30 years prior to coming to the commission last year.
Oh, great! So you're the perfect person.
And so I did a lot of IPOs before the Jobs Act, or right after the Jobs Act came in. But testing the waters started off. We understand people were a little skittish about it. I think part of it was that investors only had so much time, and they wanted to deal with deals that were real deals, not. However, we have heard anecdotally that the process is being used in a lot of deals. It was used in the biotech industry substantially, but I think now it's across the board, and we haven't seen any problems with it. And to that extent, it's helpful. We think that's great.
In the remaining 15 seconds, any other feedback with respect to IPO on-ramp provisions?
The confidential filing process has worked very well. Companies like it. It's worked well for us, and things are working well.
Great. Thanks very much. Keep up the good work.
Thank you. The gentleman yields back. Mr. Holtgren is recognized now for 5 minutes.
Thank you, Mr. Chairman. I do want to thank Director Higgins for being here. First, I'd like to focus on a line of questions that Representative Lynch brought up and wondered if you could help me understand this a little bit more. Director Higgins, as you know, in 2005, the SEC undertook securities offering reforms, which, among other things, created a new category of issuers known as the well-known seasoned issuer, or WICSI. The main purpose of creating WICSIs was to enhance flexibility in accessing capital markets. As I understand it, there are certain instances, however, where issuers that would otherwise be considered WICSIs can become ineligible and request that the Commission review their application to grant a waiver so that the entity can once again gain WICSI status. Is this correct?
Correct.
Once the request is made for a waiver, does the Commission just rubber stamp an approval on the request and call it a day?
Not at all.
Conversely, does the Commission just categorically deny all waiver requests?
The Commission doesn't. Typically, they come into the Division of Corporation Finance. We've been delegated authority from the Commission to act on the waivers, and they come in. We talk informally with companies. Companies that we talk to informally that we don't believe they would qualify for a waiver, they would show good cause. They may not. They probably don't even come in and make a request.
So it sounds like to me there is a process in place by which the Commission can consider on a case-by-case basis whether to approve or deny a waiver request. I wonder if you could walk through in a little more detail what that process is. Once a waiver request is received by you and your staff, what considerations do you give that request?
What typically happens is there's a phone call first that comes in. Our Office of Enforcement Liaison speaks with the company about the particular facts and circumstances, and to understand better whether it's totally out of the question that they would get a waiver or whether they would present a plausible case. If they think it's worth presenting a case, the company would submit a letter where they would focus on the factors that we lay out in our public guidance on when we will grant WICSI waivers, and they'll put their case forward. At that point, we will go back and forth with the letter on them, ask them questions about it, and if we're satisfied that they have made the case, we would recommend granting a waiver. The Commission can always decide to take the authority away, to decide it on its own, and occasionally they've done that. The Royal Bank of Scotland is a good example, but we do have delegated authority, and we would grant the waiver if we believe they met the applicable standard.
Thank you. So it sounds like it's a thoughtful process and not something, to me, it sensed it was being characterized as something different. Right. As I hear more, it sounds like it is a process that does work. Switching gears a little bit, the SEC has had an important threefold core mission: to protect investors, to maintain fair, orderly, and efficient markets, and also to facilitate capital formation. Certainly a key component of this mission is ensuring that investors can assess a wide variety of transparent investment options. I'd like to talk about the SEC's definition of accredited investor. This determines which investors, those deemed sophisticated, can access a wider variety of investment options. Unfortunately, I think this definition has not been significantly updated since it was first promulgated back in 1982. While this issue may be decided in Washington, it has a very significant impact on Main Street. A narrow definition of accredited investor will not only hurt potential investors in my district, but it will also cut off small businesses in my district from much-needed potential sources of capital. Thankfully, the SEC is reviewing the definition of accredited investor, and I'm hopeful it will take the opportunity to expand this definition. While I'm thankful that the SEC takes its mission to protect investors very seriously, I'm also hopeful that it will recognize that today's investor has access to a wider variety of information that was not even available 10 years ago. So my question, Director Higgins, is as follows. Linking the definition of accredited investor purely to income or net worth is an antiquated and counterproductive measurement. As you may be aware, the United Kingdom recently added 2 additional ways that one may be an accredited investor, whereby a person who does not meet the income net worth requirements would take a test or show through education or advanced degree that they would be able to assume the risks involved in investing in non-public securities. I wondered, is the division considering an educational component as you begin to update the definition of an accredited investor?
We are, as part of our review of the accredited investor definition. We are.
So you're looking at that, and you expect there will be some changes there?
I can't. I mean, it's up to the Commission to make changes, but we are definitely looking at it, and it will be a discussion of it will be part of our report.
Good. And there is an understanding, recognition how this does impact Main Street and our constituents as well, and how very different access to information is now than it's ever been before.
Right. I mean, and again, we'll get comments, I'm sure, on both sides of the issue, but we do understand the importance.
Well, again, thank you for being here. My time has expired. I yield back, Chairman.
Thank you. The gentleman yields back, and I think that brings to a conclusion today. Oh, no, there is one other member here, I see.
Thank you, Mr.
The gentleman will have the last word.
Thank you, Mr. Chairman. I appreciate the willingness of the chairman to allow me to participate in today's hearing. Just a couple of questions to wrap up. I'm going to echo what my good friend Mr. Carney talked about. He and I did have the Jobs Act the last time, the on-ramp provision in that bill. Jobs, J-O-B-S, which is what's super important in getting the economy back running, people working. That's how we produce revenue in this country. And just a few minutes ago, my good friend, I'm glad he brought up Ex-Im Bank, because that is a key part of the process, and reforming it, making it more transparent and accountable, and it's all about jobs in our districts is what's important. But back to specific questions. Former Chairman Shapiro attempted to water down the Jobs Act after it passed in the House in 2012 and before it was ultimately signed into law. I hear many SEC staffers do not like the Jobs Act, possibly because it was not invented in the SEC, at the SEC, and because Congress had to help small companies and entrepreneurs access the capital markets more effectively. Do you believe that the SEC should exhibit the same zeal, sustained effort, and enthusiasm when implementing the Jobs Act as it's done with Dodd-Frank?
I think that we should implement it faithfully in accordance with our mission, absolutely.
Do you feel that some staffers have taken that opinion that they really turned a cold shoulder to the Jobs Act?
None have expressed it to me, Congressman.
Okay. And then lastly, what is the SEC's capital formation agenda outside of the Jobs Act? Are there specific rule changes the SEC is considering that would be helpful to small companies looking to raise capital and that would distinguish them from larger companies?
Well, as we're often reminded, we've still got some wood to chop on the Jobs Act front, and we're focused on getting that done. Our Office of Small Business Policy in the division is open for business. We answer more than 1,000 requests each year from small businesses and other market participants who are interested in small business capital raising. So we're available. We're available to try to provide guidance on the rules that have already been adopted so that people can have some certainty in how they're applied, make it easier and more cost effective to do. So the division is committed to small business capital formation.
Well, with that, I yield back, Mr. Chairman. Thank you again for your patience.
It was well worth the wait. I think everyone would agree with that. Well, no one's commenting. So seriously, though, Mr. Higgins, we do appreciate your time and your work at the Commission. And just a reminder that additional questions may come in from both the members that were here and also by the members that were not here, and so we would submit those to you. Members have five legislative days to submit also extraneous material to the chair for inclusion of the records, 5 days also to submit questions to you as well. And with that, there being no further business, I thank you once again, and this hearing is now concluded. Thank you.
Thank you.